Once you're suspended or disbarred, you're basically cut off from practice before the IRS. On the EA exam, they test this as a list of do not do activities. Think, no representing taxpayers, no signing IRS agreements, and no using a power of attorney. Even if you still work in a tax office, you can't do work that crosses into IRS practice. Here are the big prohibitions. You cannot represent a client in conferences, hearings, or meetings. You cannot file a power of attorney. You can't execute waivers, consents, or closing agreements. And you can't receive a taxpayer's refund check. And a sneaky one. You can't render written advice on a plan or transaction that has potential for tax avoidance or evasion. That's a classic exam trap. Also, you can't prepare or file documents or correspondence with the IRS as a representative, and you can't borrow someone else's credentials. Circular 230 is blunt. You can't accept help from someone or help someone if it relates to practice before the IRS. And you can't state or imply you're eligible to practice. So no, I'm basically still in EA language. Ever. Now the exceptions, because the exam loves exceptions. You can always represent yourself. You can appear as a fiduciary, like a trustee, executor, or guardian, if you're properly authorized under state law. You can appear as a witness, and you can furnish information if the IRS asks for it. You can also receive IRS information under a valid tax information authorization, but that alone does not let you represent the taxpayer. The Loving case is the weird twist. Even if you're suspended or disbarred from practice before the IRS, you may still prepare and file tax returns for compensation. That does not mean you can represent the client if the return gets audited. So, paid return prep can be allowed, but IRS representation is still prohibited. On exam questions, separate return preparation from practice before the IRS. Finally, the workplace angle. A firm can't use a disbarred practitioner to do work that is really IRS practice behind the scenes, like drafting responses for signature, strategizing representation, or ghostwriting taxpayer communications. And employing them as a practitioner is a problem. If your employee gets disbarred, you generally have to remove them from any role tied to IRS practice. The exam frames this as, you can't accept assistance from a disbarred practitioner. Which action does not constitute practice before the IRS? The choices include furnishing information when an IRS employee requests it, signing a closing agreement about a tax liability, communicating with the IRS about a taxpayer's rights, or representing a taxpayer at a hearing. Think about what's merely providing facts versus acting with representative authority. Think about it. The correct answer is furnishing information at the request of an IRS employee. That's generally not practice by itself, it's just responding to an IRS request. A tempting wrong answer is communicating about a taxpayer's rights, because it sounds informational, but it's still acting on the taxpayer's behalf, which is representation and therefore practice before the IRS. Which disciplined practitioner may still represent clients before the IRS? The options are a practitioner who has been disbarred, a practitioner who has been publicly censured, a practitioner suspended for 2 years, or that none of them may practice in any capacity. Focus on which discipline actually removes practice rights versus which is basically a reprimand. Think about it. The correct answer is the practitioner who has been publicly censured. A public censure is a formal reprimand, but it doesn't automatically bar representation. Disbarment and suspension do prohibit practice before the IRS during the disbarment or suspension period. The tempting wrong choice is none, because it feels safer, but censure alone doesn't take away practice privileges.